Hello, I'm Brian Hudson from Family Court Guide. In this video, I want to talk about something that is so astonishing in the world of family courts that I still find it difficult to believe it could ever have become policy. A national safeguarding policy, which is, in practice, harming children where it purports to protect them. I'm talking about the Cafcass Domestic Abuse Practice Policy. And when that policy is applied mechanically and in blanket fashion, as it very often is, it has separated thousands of children from a parent for months, sometimes years, on the basis of nothing more than unsubstantiated allegations, very often when there is clear evidence presented but ignored that the allegations are not true. For the sake of adherence to policy taking precedence to both clear evidence and the welfare needs of the children concerned. Here's how it works. A parent makes an allegation. Contact is suspended instantly. Police investigate. They find no case to answer, but contact doesn't resume. Why? Because Cafcass officers say policy requires that contact remain suspended until the allegations are resolved, even when they already are, even when clear evidence is presented to them, and even, believe it or not, when there is clear evidence that the accusing party has knowingly and intentionally made those allegations to sever contact, and even when there is clear independent reporting as to the harm being caused to the children through the severance of contact and alienating behaviours of the accusing parent. To illustrate how this plays out in practice, let me describe a composite example drawn from several anonymised cases. In these situations, a parent, often the father, suddenly loses all contact with his children after allegations of domestic abuse are made. The police are called, investigations begin, and bail conditions are imposed. Yet after careful investigation, no further action is taken. There is no evidence to support prosecution, but contact with the children remains suspended. After a period of quiet, new allegations appear, often variations on the same theme. Each time, the process repeats. Investigation, no evidence, but ongoing separation. In some of the cases I've seen, it later emerged that similar allegations had been made years earlier and later withdrawn without the other parent even knowing. Throughout all of this, Cafcass continues to recommend that contact be suspended, pending resolution of the allegations, even when those allegations have already been investigated and closed. The justification is always the same, that this is in accordance with Cafcass policy. Eventually, supervised contact begins. Observers record warm, natural interactions between the parent and their children, but also worrying signs that the children have been exposed to adult narratives about the case. They talk about evidence and they talk about court hearings, words that no young child should be repeating. Across these composite examples, the pattern is the same. The children remain separated from a parent for many months and sometimes years. Not because a court found a risk of harm, but because policy dictates it. That is not safeguarding. It is systemic failure. The independent contact supervisor reported warmth and affection between the children and their father, but they also saw signs of coaching and parroting allegations that the mother had made in her witness statements. When this evidence was given to Cafcass, their position didn't change, and they sought to suspend all contact again until the outcome of a fact-finding hearing, which could be between 6 and 12 months later. That's when I realised this isn't about evidence anymore. It is about overreach of Cafcass powers to place courts in a position where they will prioritise policy over the consideration of evidence in reaching a judgment. That very policy provides parents who will falsely accuse and go on to alienate their children with an extensive window of opportunity to poison the relationship between their children and the other parent, and potentially sever that relationship permanently. The law is clear. Under the Children Act 1989, a child's welfare is paramount. There's also a presumption that both parents should be involved unless that involvement would cause harm. Cafcass's policy reverses that. It assumes harm unless the parent can prove otherwise. But even when they can prove otherwise, the accusing parent is gifted a lengthy window of time where the children's relationship can be permanently damaged with no oversight, no due diligence, and no intervention. That's not just unfair, it's unlawful. It breaches both Article 8 of the European Convention, the right to family life, and Article 6, the right to a fair hearing. And it violates a core principle of public law, that no public body can apply policy so rigidly it ignores the facts before it. After reviewing evidence, a Cafcass officer says, "My advice to suspend contact remains the same, as this is Cafcass policy." That is already acting outside the law. The purpose of Cafcass officers in these situations is to exercise professional judgment, not to hide behind bureaucratic rules. Should affected parents and lawyers now begin preparing a collective legal challenge, a respective judicial review to compel Cafcass to rewrite this policy? Will leading counsels come forward to consider whether they agree with me and take the view that this policy is likely to be declared unlawful if it's tested in court? A pre-action letter would be the first step in testing Cafcass' commitment to this policy in the face of a legal challenge, which doesn't simply threaten to force them to rethink and rewrite this policy, but would draw serious questions about how and why they are imposing this demonstrably harmful policy in a blanket fashion, prioritizing their policy over the very child welfare they are legally obliged to place above all else. Safeguarding should protect children from harm, but when a public body's own procedures and policies become the source of that harm, the law has a duty to intervene. No one is saying genuine victims shouldn't be protected. They must be. But protection and presumption are not the same thing. When untested allegations automatically end a child's relationship with a parent, something fundamental has gone wrong, and the motivation of those behind such policies must be scrutinized. The question now is simple. When safeguarding fails, who safeguards the children from the system itself?